So thank you so much to John, Jonathan, Paul and Laura for inviting me to speak to you, and I'm very sorry not to be able to do so in person. But as I'll no doubt have explained, we're currently in the process of running a new undergraduate system in Oxford in a year with teacher-assessed grades, so it just hasn't been possible for me to join you. But I'm particularly delighted to speak to you because I think this is a very important issue, and the current law is in urgent and serious need of reform. Even labelling the conceptual line between Assange and Lawrence incredibly fine, as the organisers do, is arguably very generous, given that that line might actually be described as non-existent. Thus, if we consider the various cases decided on this issue recently, as I've shown on the slide, none of the women in Assange, F, B and Lawrence consented to the presence in their bodies of a particular physical entity. The victims in Assange and F had not consented to any ejaculate. The victim in B had consented to semen, including sperm, but not the presence of the HIV virus, and the victim in Lawrence had consented to semen, but not to sperm. All, therefore, lacked consent in relation to one specific aspect of the physical act. So on this basis, there is no conceptual or normative distinction between Lawrence and these other cases. However, in McNally, actually the victim had consented to digital penetration, and that was what in fact took place. The difference was simply that the owner of the fingers had been assigned female at birth rather than male. So if one case were to be singled out as not leading to criminal conviction, we might expect it to be McNally, and yet it was just assumed that McNally fell within the line drawn by Lawrence, while the facts of Lawrence itself did not. The result of this lack of a rational distinction between the existing cases makes the future application of Lawrence's sufficiently close connection rule unpredictable. We know already from cases such as McNally and Jeter that it's not clear to defendants when they should plead guilty and when they should not, and we know that this unpredictability has actually been prevalent in the area since the 2003 Act. But the double uncertainty of A, the fact that the court changed approach in Lawrence yet again, and B, that it did so by introducing a test which itself is very uncertain, seems hardly likely to improve the situation. The unpredictability of the sufficiently close connection test also gives rise to another difficulty. Sufficiently close according to whom? The answer is obviously the court in the particular case, but this will not necessarily match either the views of the participants or of society more widely. Again, this has long been a pervasive feature of this area of law. See, for example, the two specific scenarios singled out for special prohibition in Section 76. This lack of certainty and reliance on the view of the court seems highly likely to lead to a discriminatory application of the law of the kind highlighted by Sharp in relation to McNally. So how should the law be reformed? Well, even under the common law, we should, for these reasons, avoid general tests such as sufficiently close connection, and we should instead have a series of coherent and clearly distinguishable categories of misapprehension to which we could add on a case-by-case basis. Three initial categories with which we should start would be physical difference of the kinds I've outlined here, non-est factor mistakes of the kind in Flattery and Williams, and cases where D claims some legal qualification, deception as to which is separately criminalised by the law, such as false claims of medical qualification or marriage. But better still would be to pick up on the Court of Appeal's suggestion that these issues require debate as a matter of social and public policy, and to restructure this area of the law more generally. So what form should that reform take? Well, it's been suggested by John Spencer and others that we could enact a new version of the old Section 3 Sex Offences Act 1956, procuring sex by false pretences. Well, we could, but this would not fit well within the current scheme of offences. At present, either V does consent or V doesn't. If V does not consent, then the usual offences such as rape can be made out. If V does consent, then it's not immediately clear within the logic of the 2003 Act why we would make that a criminal offence. This is the whole problem. Consent within the 2003 Act is binary, yes or no. But this suggestion might point the way to a better option. The whole concept of fraud in English law is more familiar in the context of property offences, which is divided up according to the method of vitiation of consent. In a way, it's not surprising that the law relating to sex by deception or misapprehension has been tangled and difficult. As Farmer points out, the perceived purpose of sexual offences has varied over time through concerns with morality, religion, public economy and public health. But in the more recent acts, as Farmer puts it, consent is framed in positive terms as not merely submission or acquiescence to the desires of another, but a negotiated interaction or agreement in which the needs and desires of both parties are expressed and respected. Sex, it is argued, is a valued human activity, such that the criminal law ought to protect our interest or right to pursue that end as we choose. Thus, the role of sexual offences is quite different from that of homicide or of the non-sexual, non-fatal offences against the person. The desired level of activity in those categories is 0. So, for example, even though we do want people to undergo medically necessary surgery, we're constantly looking for ways such as keyhole or laser surgery to minimise the extent to which offences against the person are necessary. But this is not true for sexual activity. We're not trying to minimise it. So although sexual offences and the law of property offences have had a problematic relationship in the past, now the two actually align well on the basis that in both, the law is concerned not with prohibition, but with drawing the line between desirable and undesirable activity. This also fits with Green's view of the law as concerning a bundle of rights organised around the idea of securing for the right of the holder exclusive possession of, use of, access to or control of a resource. It also seems likely that the law relating to sex by deception or misapprehension has struggled with the same concerns Green notes in relation to the criminalisation of fraud in the property context, including a problematic sense that V may be to blame for being too trusting, a sneaking admiration in popular culture for both fraudsters and Lotharios, and a concern that the line between legitimate and illegitimate activity may be hard to locate. So rather than reinvent the wheel in two different areas by keeping them separate, we should instead examine them consistently with each other and deal with these problems across both. If we look at how the offences in each of these areas are structured, at present, as I mentioned before, the law of consent in sexual offences is essentially binary, and then the law is divided up by reference to which bit of D touches which bit of V. By contrast, as Green so engagingly puts it in the title of his book, 13 Ways to Steal a Bicycle, property offences are essentially structured according to the method by which consent is vitiated. And indeed, Gardner suggested that we can actually regard the harm of loss of property as being aggravated by a further form of injury in situations of theft plus, such as theft plus force in robbery or theft plus deception. This is also reflected in the greater sentencing available in such cases and suggests that this structure is not just coincidental but intentional. And of course, clear parallels can be drawn between these different property offences and the different ways in which sexual offences might occur, as I've indicated on this slide. When viewed like this, the question doesn't appear to be so much why we would want to analogise the two areas of law, but why we don't currently protect sexual autonomy in the comprehensive and nuanced way that we protect economic autonomy. So my argument is that we should replace the single offences of rape, sexual assault and so on in the 2003 Act with offences of rape by stealth, rape by force, rape by fraud and so on. This would retain the use of the term rape, which seems likely to be important both to victims and to the government proposing the necessary legislation. There are, of course, arguments against this proposal. First, it might not be thought to fit immediately with public opinion. But the law can lead as well as follow, as Robinson has demonstrated, and it has done so in various contexts including drink driving, domestic violence, and more recently in areas such as upskirting and revenge porn. Second, structuring the law in this way may lead to difficulties where there's an overlap and the facts fall into more than one category of offences, as might be the case for fact situations such as those in Jeter and Bingham. But that's true of property offences too, in cases such as Hinks, Barton and Lawrence, and one of the advantages of bringing the two areas together is that we can adopt existing solutions or achieve consistency by dealing with these questions in the same way across both. And note conversely what's at stake in these cases: coherence, certainty and the predictability of the law in terms of things like guilty pleas, as well as the protection of sexual and reproductive autonomy and general health. So thanks again for inviting me and thank you for listening. I'm even more sorry that I can't take questions in person, but if you'd like to get in touch, please do so using the email on this slide.